The call came in at 6:47 on a Thursday morning. I remember the exact time because I was standing in my kitchen, still in the clothes I'd slept in, trying to coax a cup of coffee out of a machine that had decided, for reasons known only to itself, to produce something closer to warm brown water than anything resembling caffeine. My phone buzzed against the marble countertop, skittering toward the edge like it was trying to escape, and I caught it without thinking. The name on the screen read Derek Holt. I almost let it go to voicemail. I wish, in retrospect, that I had. Not because of how things eventually turned out, they turned out beautifully in the end, but because that single answered call cost me 4 months of my life, 3 inches off my waistline from stress-induced appetite loss, and somewhere in the neighborhood of $11,000 in legal fees before the whole magnificent disaster resolved itself in my favor. But I'm getting ahead of myself. My name is Karen Webb, and at the time of the story, I was 43 years old and the sole owner of a commercial real estate holding company called Ridgeline Property Group. I'd built it over 15 years from a 2-desk operation above a sandwich shop in downtown Columbus, Ohio, into a firm that managed a portfolio of mid-market commercial properties, office parks, light industrial facilities, a handful of mixed-use developments on the edges of growing suburbs. Nothing that would make the national papers, but enough to make me comfortable, respected in my industry, and occasionally invited to speak at regional conferences where I'd give sensible talks about market cycles and due diligence. Being a woman in commercial real estate had never been something I dwelled on, but it was always there, a low hum in the background of every negotiation, every handshake, every room I walked into where I was the only one carrying a handbag. I'd learned early that the fastest way to be taken seriously was simply to know more than everyone else at the table, and I had spent 15 years making that my singular competitive advantage. I was not flashy. I drove a 4-year-old Volvo. I wore the same rotation of blazers until my assistant quietly suggested they were starting to communicate a certain indifference to my own success. My employees liked me because I paid fairly and kept my word, and my competitors respected me, most of them anyway, because what I said I would do, I did. Derek Holt was everything I was not. He had arrived in the Columbus market about 2 years before our story begins, trailing a reputation that had preceded him from Philadelphia like a bad smell. He ran a firm called Holt Capital Ventures, which operated with the kind of aggressive, acquisitive energy that you either admired or feared depending on your position relative to it. He bought things, properties, companies, reputations, and he squeezed them, and then he either flipped them for profit or discarded them when they stopped performing to his expectations. He was known for 3 things in particular. First, he was extraordinarily charming. The kind of charm that made you feel, when he was looking at you and speaking to you directly, that you were the most important person he had encountered in years. The kind that made you want to agree with things before he'd finished saying them. Second, he had a team of lawyers who were, by reputation, among the most aggressive in the Midwest. They were not evil, exactly, but they were thorough in the way that a controlled burn is thorough. They didn't leave much behind. Third, and most relevantly to our story, he had a documented history of backing out of deals at the last possible moment using procedural technicalities, leaving the other party stranded with legal costs, wasted preparation time, and occasionally a property that had been held off market for months during due diligence. 3 people had warned me about this before I ever shook his hand. My broker, Carol Eames, had pulled me aside after the offer came in and said, with the measured tone of someone choosing their words carefully, "Karen, the number is real and the man is not." A developer I'd known for a decade named Phil Garrett had sent me a text that read simply, "Holt, be careful." And a woman named Sandra Cho, who ran a property management firm in Cleveland and had met Derek Holt at a conference 2 years prior, had called me unprompted to tell me that he had strung along a seller in Pittsburgh for 90 days before invoking an inspection clause so buried in the contract that the seller's own attorney had missed it. I smiled, thanked all 3 of them, and proceeded anyway. Which tells you something about either my confidence or my stubbornness, and I'll let you decide which. Though anyone who has spent 15 years being underestimated will probably understand that the two are not always easy to separate. The property in question was called West Park Commons. It was a 340,000 square foot mixed-use development I'd assembled over 4 years in a suburb called Glendale, about 18 miles northwest of Columbus. I'd bought the parcel separately, navigated the rezoning process through 2 contentious city council sessions, secured the financing, managed the construction, and then leased it up over 22 months to a tenant roster I was genuinely proud of: a regional grocery anchor, a medical group, 2 restaurants, a fitness concept, and 17 other tenants ranging from an insurance office to a children's tutoring center. It was, without question, the best thing I'd ever built. Not the most profitable, not yet, but the one that had required the most from me. There were nights during the rezoning battle when I'd sat in my car outside City Hall at 11 o'clock, eating a gas station sandwich and reading planning commission notes on my phone, certain that the whole project was about to collapse. There were mornings during construction when I'd walk the site before dawn just to remind myself that it was real, that the thing I'd imagined on paper was actually rising from the ground. I'd poured something essential into West Park Commons, and I'd decided to sell it. The decision was partly financial. The market was at a high, and a sale would generate capital I could redeploy into 3 or 4 smaller acquisitions that would diversify my portfolio. It was partly practical. A property of that size demanded a level of management intensity one was no longer willing to give it. And it was partly something I couldn't fully name at the time, a readiness to close a chapter and write a new one. I listed it through Carol Eames, who had 20 years in the Columbus market and a network that seemed to encompass everyone who had ever written a check for commercial real estate within 100 miles. She brought me several interested parties within the first 6 weeks. Derek Holt's offer came in at the end of the 2nd month. It was $23.4 million. In a market where I'd have been quietly satisfied with $21 million and openly delighted with $22.5 million, it was a number that made me sit down when Carol read it to me over the phone. "That's the number," I said. "That's the number," she agreed. And then, after a pause, "Karen." "I know," I said. "The man does not pay what he offers." "I know, Carol. He offered a seller in Pittsburgh $21 million, walked it back to 18.5 through inspection contingencies, and then pulled out entirely on day 89 of a 90-day due diligence window. The seller had turned down 2 other buyers by that point." "I know all of this." There was a longer pause. "What do you want to do?" I looked out my office window at the parking lot below, where my assistant was walking back from lunch with a takeout bag, and I thought about the 4 years I'd spent building West Park Commons and the 15 years I'd spent building the kind of reputation that could attract a $23.4 million offer in the first place, and I thought about Sandra Cho's phone call and Phil Garrett's text and the quiet, steady certainty that had carried me through every difficult moment of my professional life. "I want to take his offer," I said. "And I want to write the contract myself." Here's something that people outside the commercial real estate industry may not fully appreciate. The purchase and sale agreement for a transaction of this size is not a form you fill out. It is a negotiated document, sometimes running to 80 or 90 pages, containing provisions that are argued over, revised, struck through, and reinserted in modified form over days or weeks of back and forth. Most sellers in my position would have handed the drafting to their lawyer and stepped back. I did not do that. I had my attorney, a meticulous woman named Diane Forsyth who had been my counsel for 9 years, prepare the initial draft, but I sat with her for 6 hours over 2 sessions and went through every provision line by line. I was looking for something specific. Or rather, I was looking to build something specific into the document that Derek Holt's lawyers would skim past without fully absorbing, because it would be buried in language that sounded standard, protective, and entirely in the buyer's interest. It took Diane and me the better part of an afternoon to construct it properly. What we built was a seller's performance compliance clause, which sounds, if you encounter it in a contract without reading it carefully, like a provision protecting the buyer against a seller who fails to disclose property defects or deliver required documentation on time. It is the kind of clause that buyers' attorneys see and nod at approvingly because it appears to hold the seller accountable. What it actually did, in the specific form we drafted it, was this. It required the buyer to confirm in writing, within 5 business days of each of 4 milestone dates during the due diligence period, that they had received all requested materials from the seller and that the seller was in full compliance with their disclosure obligations. If the buyer failed to provide this written confirmation by the deadline, even by a single day, it constituted a material breach of the buyer's obligations under the agreement, giving the seller the right to terminate the contract and retain the earnest money deposit. The earnest money deposit Derek Holt had agreed to was $700,000.
Now,
There are two important things to understand about this clause. The first is that it was entirely legal. There was nothing deceptive about the language itself. A careful attorney, reading it slowly and with full attention, would understand exactly what it required. Diane had made absolutely certain of that, because she was not willing to participate in anything that wasn't above board, and frankly, neither was I. The second is that it was drafted to look, at a glance, like 20 other standard compliance provisions that appear in commercial real estate contracts. The obligation it created, the buyer's written confirmation, was worded in a way that blended naturally into the surrounding language. It did not announce itself. It did not arrive with flashing lights. Derek Holt's attorneys reviewed the contract for 4 days and requested 17 modifications. None of those modifications touched the seller's performance compliance clause. They signed on a Tuesday in late March. The due diligence period was 90 days. Derek Holt moved through the first 6 weeks the way I expected him to. His team was thorough, professional, and relentless. Environmental assessments, structural inspections, lease audits, estoppel certificates from every tenant, a zoning review, a title search that felt more like an excavation. They found 2 minor issues, both of which I'd already disclosed and budgeted for, and his attorney sent me a letter suggesting that these issues warranted a $400,000 price reduction. I sent back a letter, drafted by Diane, that was 4 paragraphs long and used the phrase, as fully disclosed in Schedule C of the original offering memorandum, twice. The price reduction request quietly disappeared. Then came the first milestone date. Under our contract, 60 days after signing, Derek Holt's team was required to provide written confirmation that I was in full compliance with my disclosure obligations. The deadline was a Friday. I had, in fact, provided every single requested document ahead of schedule. My compliance was not in question. The confirmation was, from Derek Holt's perspective, a formality, a piece of paper that meant nothing except that everything was proceeding as it should. I waited. Friday came and went. No confirmation. I called Diane on Saturday morning. Nothing, I said. Nothing, she confirmed. She had been watching her inbox with the same attention I'd been watching mine. So we're in breach territory. Technically, as of midnight last night, yes. She paused. Karen, you understand that if you exercise this right, it will be contentious. I know. His lawyers will challenge it. There will be litigation. It will be expensive and unpleasant. I know, Diane. And the property goes back on the market. You lose 4 months. I was quiet for a moment. Outside my kitchen window, the same kitchen where I'd stood on that Thursday morning 4 months ago when this whole thing began, the neighborhood was soft and green in the early summer light, and my neighbor's kids were running through a sprinkler in their front yard, shrieking with the particular joy of children who have not yet learned to be cautious. What I lose, I said carefully, is 4 months and Derek Holt's offer. What I keep is $700,000 and the knowledge that he doesn't get to do this to the next person. Not with my property. Diane was quiet for a beat. All right, she said. I'll draft the termination notice. I want to be precise about what happened next, because the story has a way of sounding more dramatic in the retelling than it actually was in the moment. The termination notice went out on Monday morning, certified mail and email simultaneously. It was 3 pages long, cited the specific clause and the specific deadline, and was written in the kind of calm, factual language that Diane favored. No heat, no triumph, just a clean and thorough statement of position. Derek Holt's response came 4 hours later by phone. He called my cell directly, which told me that his attorneys had recommended against it, and he'd ignored them. Karen. His voice was the same voice I'd heard in our first meeting, warm, reasonable, carrying the faint suggestion that whatever misunderstanding had arisen between us could surely be resolved by 2 sensible adults. I think there's been a miscommunication about a procedural item in the contract. There hasn't been a miscommunication, Derek, I said. I was sitting at my desk, Diane on a conference line that he didn't know about, a glass of water in front of me that I hadn't touched. The deadline was Friday. The confirmation wasn't provided. The contract gives me the right to terminate, and I've exercised it. That clause was a standard compliance provision. It was a provision with a specific deadline and a specific consequence for missing it, both of which your attorneys reviewed. A pause. When he spoke again, the warmth had cooled by several degrees. You're going to want to think carefully about this. We have a signed contract. We had a signed contract, I said, which I've now lawfully terminated. You'll receive the formal notice of earnest money forfeiture from my attorney's office by end of day. There was a silence that lasted long enough that I wondered, briefly, if he'd hung up. Do you have any idea, he said finally, and his voice had changed completely now. The charm was gone, and what was underneath it was neither warm nor reasonable. What kind of resources I can bring to contesting this? I had thought about this moment. I had thought about it quite a lot, actually, over the preceding weeks, in the quiet intervals between due diligence requests and lease audits and the ordinary business of running a company. I had thought about what I wanted to say, and I had decided that I did not want to be clever or cutting or to deliver some perfectly crafted line that I'd been rehearsing. I just wanted to be honest. I'm sure they're considerable, I said. But Derek, I want you to understand something. I knew who you were before I took your offer. I built that clause specifically for this transaction. And I waited to see whether you'd honor the contract you signed. You didn't. So, yes. Bring whatever you'd like to bring. I'm ready for it. I hung up. Diane, on the conference line, said nothing for a moment. Then, that was very well done. He contested it, of course. His attorneys filed a formal challenge arguing that the seller's performance compliance clause was, in essence, a trap, that it had been designed to create a technical default that bore no relationship to any actual breach of the underlying transaction. They were not entirely wrong about the intent, though they were entirely wrong about the legality. Diane responded with a brief that was, if I'm being honest, a small masterpiece of measured legal reasoning. She acknowledged the clause's unconventional structure, cited 3 precedents for seller protective compliance provisions in commercial transactions, and noted, with a kind of quiet precision that I had come to recognize as Diane's particular form of devastation, that the buyer had been represented by a team of 4 attorneys who had reviewed the contract over 4 days and raised 17 modification requests, none of which had touched this provision. The implication being, if the clause was a trap, it was a clearly visible one that a team of experienced attorneys had walked past with their eyes open. The matter went to mediation rather than litigation, which surprised me slightly. I think Derek Holt's attorneys, on reflection, had advised him that his chances were poor and his legal costs would be high. The mediator was a retired judge named Howard Calloway who had 30 years of commercial dispute experience and who listened to both sides with the expression of a man who had heard everything. We settled in a single session. Derek Holt received $175,000 of his deposit back. I kept $525,000. He did not attend the mediation in person. He sent his attorneys, which I understood but which, I'll admit, disappointed me slightly. I had a few things I'd been looking forward to saying to him in a room with witnesses. I relisted West Park Commons 3 weeks later. Carol Eames, who had watched the entire proceeding from a professional distance while trying very hard not to express anything other than neutral concern, called me when the listing went live. "You actually did it," she said. "I actually did it. $525,000. Give or take." A pause. "Karen, can I ask you something?" "Of course." "Were you certain?" "The whole time. Were you certain it would hold up?" I thought about the honest answer to that question. I thought about the nights I'd spent reading case law at my kitchen table, about the conversation with Diane where she told me there was risk, real risk, and I'd said I understood. About the Saturday morning phone call when I'd sat with a cup of coffee and looked at the green light in my neighbor's yard and decided, with a clarity I haven't always had about everything, that some things were worth the cost of standing up for them. "No," I said. I wasn't certain, but I was prepared. West Park Commons sold 7 weeks later for $22.1 million, $1.3 million less than Derek Holt's original offer, but a number I was genuinely happy with, to a buyer who closed on schedule and without a single missed deadline. On the day of closing, I sat in Diane's conference room and signed my name 31 times on various documents, and when it was over I shook hands with the buyer's representative and thanked Carol for everything she'd done, and then I drove home in my 4-year-old Volvo and sat in my driveway for a few minutes in the quiet. I thought about the 4 years I'd spent building West Park Commons, about the city council sessions and the late nights and the early mornings on the construction site, about Phil Garrett's text and Sandra Cho's phone call and Carol's patient, worried face through all of it. And I thought about Derek Holt, somewhere in Columbus or Philadelphia or whatever city he was currently moving through, and I thought, he will do this to someone else. He will find someone less prepared, and he will do exactly what he planned to do to me. That was the one part that didn't feel like a victory. But I had done what I could do. I had protected myself, and I had taken something from him that he had planned to take from a version of me that he had clearly decided, before we ever shook hands, was not paying attention.
He had been wrong about that.
He had been wrong about a lot of things. I got out of the car, walked into my house, made a cup of coffee that actually tasted like coffee, and got back to work.